Mr. Smith, you have a long tenure at the Department of Justice. Would you agree with the statement that DOJ charging policies require prosecutors to bring charges only where the admissible evidence is expected to be sufficient to obtain and sustain a conviction? Is that right?
That is correct. That's from the federal principles of prosecution.
And in this case you brought against President Trump, one of the charges you pursued was under Title 18, Section 371, which requires an agreement to interfere with the lawful function of the United States through deceit or dishonesty that the defendant knowingly and intentionally joined, and an overt act. And what I'd like to ask you about is this. So you would agree that Section 371 requires dishonesty or deceit and also proof that a criminal defendant acted knowingly and intentionally. Is that right?
I believe that's correct. It requires knowing deceit targeted a lawful government function.
So you would then also agree, would you not, that opinion, disagreement, or even mistake is insufficient to satisfy the burden of criminal intent set forth in that statute?
A mistake certainly would. We needed to prove and intended to prove at trial that the false statements that Donald Trump made were knowingly false.
That they were false and that it was done knowingly. So even under your theory of the case, even if we took your facts as true, you still would have been required to prove that the president said something false and that he did it knowingly. So going on to your next charge, let's talk about obstruction. There too, that charge requires proof of wrongful intent, does it not?
That's correct.
So if a defendant there actually believes a factual claim is true, that would mean he could not be convicted of that charge. Isn't that right?
Well,
not correctly convicted.
The defendant for that charge would have to behave corruptly, and corruptly could include seeking an unlawful benefit, seeking a benefit to benefit themselves, in this case, to stay in office when they had, in fact, not won the election.
But there, too, there's a requirement of intent, that this conduct must be knowing and intentional. Isn't that right?
There is an intent requirement, yes.
And didn't you also acknowledge in your deposition that the president was receiving information from multiple advisors? Giuliani, Eastman, Clark, Powell, and in your deposition you said he was almost just regurgitating what they told him. Isn't that right?
I don't believe I said he was regurgitating what they told him. I think what I said is that he was making knowingly false claims, that he was believing anything that would keep him in office, and he was rejecting anything.
But you would agree that those people, or some people, were giving the president conflicting advice at that time, would you not?
You're correct in that his original campaign staff told him he had lost. He fired them and brought in people who would...
But criminal liability, under the statutes you used in your indictment, requires proving intent. Not simply the undermining of democratic norms or expressing an opinion with which you do not agree. So is it not correct, sir, that here you charged 2 intent-based crimes without any direct proof whatsoever that the conduct charged was knowing, intentional, or that you were going to have an adequate basis to sustain a conviction at trial?
I felt we had proof beyond a reasonable doubt. I felt that that proof included direct testimony from a number of witnesses to prove the knowing falsity of his claims.
Despite the fact that in your own deposition you acknowledge the existence of conflicting advice. If this defendant were anyone other than Donald J. Trump, Mr. Smith, I find it hard to believe that we would be sitting here today having a hearing about an indictment that was returned knowing that the elements of the offenses could not be demonstrated. Now, let's talk about this. I assume you're also familiar with the Department of Justice policy that prohibits prosecutors from selecting the timing of investigative or prosecutorial actions for the purpose of effecting any election.
Yes, I am. That's the election year sensitivities policy, and we followed it in all respects. The public integrity section, who administers that policy, concurred that we followed it in all respects.
Mr. Chairman, my time has expired.
The gentlelady yields back. The